I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. This week we have another status report on the U.S. Supreme Court. This week there were two notable events in the bankruptcy arena before the High Court in Washington. First off, on Tuesday, February the 19th, the Supreme Court denied certiorari in a case called Ritter v. Brady. Now that's a big deal because that case, had the Supreme Court decided to take it, would have asked the justices to reverse their 1992 decision in Dewsnip. You'll recall that Dewsnip is a case which says, really quite contrary to the plain language of the Bankruptcy Code, that a debtor in Chapter 7 cannot strip down or strip off an underwater unsecured mortgage. Had Dewsnip not been on the bank books, believe me, the financial crisis after the collapse of Lehman Brothers would have been a very different story, and a lot of people could have avoided foreclosure by using relief under bankruptcy. But in any event, the Supreme Court is not going to review Dewsnip now, and I think probably never, even though I think it was 3 years ago in the Colquette case, the majority of the justices pretty clearly indicated that they thought Dewsnip was wrongly decided. But Dewsnip was not a matter of constitutional law. Rather, it was statutory law, which Congress could have fixed if they believed that the Supreme Court was wrong. But of course, Congress has not, and the Supreme Court is very, shall we say, reluctant to reverse its own precedent when Congress could have fixed it if it were wrong. The second matter we report about is the oral argument on February 20 in a case called Mission Product versus Technology. Now this is a really big deal too, but I think mostly so in the area of trademarks, because the case asks the Supreme Court to say whether or not the rejection of a trademark license bars the licensee from continuing to use the mark. Now this decision won't be just about trademarks, because it's going to give the justices to say something about what rejection means. Among other things, they have the opportunity to say whether or not rejection also amounts to rescission or an avoidance power. This is going to be a pretty complicated decision to hand down, and I suspect it's going to take a good 8 weeks before we get an opinion. And by the way, I'm expecting an opinion, I'd say within the next 2 weeks or so, in the first bankruptcy case that was argued this year in the Supreme Court, namely the Obdusky case that has to do with whether or not the FDCPA applies to non-judicial foreclosure. Well, keep your eye on my column and the ABI website, and we will report when events happen in these 3 Supreme Court cases, and for that matter, in anything else that important happens in the bankruptcy community. Until next week, this is Bill Rochelle signing off, and in the meantime, don't work too hard and be sure you spend enough time with your kids.